Very good morning, students. Today we'll be dealing with the another section, that is section 8, which deals with operation of transfer. Students, what do we mean by the term operation of transfer? And whenever the transfer takes place, what are the incidents or what are the acts which we can see that takes effect from the very moment when that property is transferred from one person to the another person? So today's topic will be we will be dealing with operation of transfer. Now suppose if a transfer takes place, because operation of transfer means what? Whatever the property has been transferred from one person, one living person to another living person, while giving that particular property or conveying that particular property, certain important essential ingredients must be there. As we have seen regarding the competency of the transferor, there is no competency over the transferee apart of just suppose if we are transferring an actionable claim, then there is definitely a transferee need to have a qualification that he do not he cannot be a judge, he cannot be a legal practitioner, nor he could be any of the officer who is associated with the court. So apart of that, there is no any other qualification which has been given by the Transfer of Property Act, which is in relation to the transferee. But whenever we transfer the property from one person to the another person, certain effects takes place, and certain effects are of the effects of transfer. Now what are those effects? That is what we are going to see. Unless a different intention is present, a transfer of property passes all the interest which the transferor is capable of passing in the property. Now, when we are transferring a property from one person to the another person, then in that case, the title relating to that particular property, the benefit relating to that particular property, the rent or the other profits which are arising out of that particular property gets conveyed from one person to the another person. But suppose, because we have even in our last lecture dealt that a property may be transferred absolutely, may be transferred conditionally, may be transferred wholly, or may be transferred partially, right? So unless a different intention is present, that is to say, if the transferor want to limit or want to pass only a limited interest in that particular property to some another person, that is to say to the transferee, then in that situation we would consider that entire interest relating to that particular property is not transferred from transferor to the transferee, but only a limited interest has been transferred. But if it is not so, then in that case, that is to say, if a situation wherein the entire interest, the whole interest in the property is transferred, then in that case, all the incidents which are attached to that particular property, which is a subject matter of a transfer, would pass from one person to the another person. So here, unless a different intention is present, a transfer of property passes all the interest which the transferor is capable of passing in the property. Another important aspect in this particular sentence is whatever the interest the transferor is transferring to the transferee, the transferor must be capable of passing that interest in the property. If he himself do not own that particular interest in the property and right to dispose of that particular interest in the particular property, then in that case he won't be in a position to create a valid transfer. Suppose for example के तौर पे I have let out my property to Roshan, and if Roshan, to whom I have let out my property, been not given a power to sublet the same, but if Roshan sublets that particular property to Shwetal, then in that case, what would happen? This transaction would not be considered to be a valid one. So, what is important? The transferor, that is to say, the Roshan should have been in a position to transfer the right which he is having by way of a tenant, and not that right which he do not possess as a tenant. So unless a different intention is present, a transfer of property passes all the interest which the transferor is capable of passing in the property. Now next is the transferee gets its legal incidents. Now legal incidents means what? Suppose if I transfer a property to Naveen, then in that case Naveen would be getting, and I am transferring that property wholly to Naveen, then in that case the Naveen would be getting a ownership over that particular property, that is to say the title over that particular property, the right to dispose of that particular property the way he likes. Suppose if you want to sell the property, he would be in a position to sell the property. Suppose if you want to mortgage it, then in that case he will be mortgaging it. Suppose if you want to lease it, he can lease it. Suppose if you want to gift it, he can gift it. So whatever the incidents which are attached to the property, which is the subject matter of transfer, then in that case the transferee gets the legal incidents. Whatever the legal things which are attached to that particular property would be conveyed from one person to another, provided the transferor transfers the property with an intention to transfer that particular property with all its legal incidents to the transferee. Now this is the effect of the transfer. Now, what is actually the object and the principle of this section? Now, what is the object and what is the principle of this section? Object says that it is clearly defined what are legal incidents of each particular class of property which pass along with the property when it is transferred. So, object means what? Whatever the property being transferred from one living person to another living person, then in that case, and that too without any condition or without any restriction, that is to say wholly the property is transferred from one person to another person, then in that situation what are the legal incidents which are attached to that particular property would pass from one person to the another person, that is to say from the transferor to the transferee. So very object behind this particular section is to transfer the interest which the transferor possesses for the purposes of betterment of that particular property, for the purposes of multiple alienation relating to that particular property, for the purposes of enhancing the value of that particular property, because for the reason that the number of times we alienate that particular property, the number of times its value get multiplied. So the object is what? It is clearly defined what are the legal incidents of each particular case. Suppose if, for example, if I am selling out that particular property, then in that case what are the legal incidents attached to it? The legal incidents attached to it may be the easement attached to it, maybe the rent and the profit attached to it, maybe the benefits arising out of that particular property, maybe the title relating to that particular property. So maybe the machineries which we have fixed in that particular property with the purpose of permanent use, then in that case all those things would be transferring from one person to another. So it is to clarify, clearly define what are the legal incidents of each particular class of property. Every particular class of property would be having its legal incidents. Now what is particular class of property? The property which we are actually making or conveying for the purposes of sale would be one class. The property which we are conveying for the purposes of mortgage would be another class. The property which we are conveying for the purposes of gift, then in that case that would be a different class. Apart of that, movable and immovable property would constitute a separate class. But so far as the transfer of property is concerned, we have to limit our thinking towards only the immovable property is concerned, and hence we would be categorizing this immovable property and the incidents relating to this particular property in relation to this particular section 8 itself. So it is to clearly define what are the legal incidents of each particular class of property which pass along with the property when it is transferred. Now suppose, for example, what is actually the principle behind this section? The principle behind this section is grantor shall not derogate from his own grant once the person has given the thing in grant. Once the person has granted the thing, maybe in any of the form he has granted, maybe in the form of a sale, maybe in the form of a mortgage, maybe in the form of a lease, or maybe in the form of a gift, whatever he has in the form transferred the property from him to some another person, then in that case he should not actually transfer in such a way wherein it becomes a derogate to his own grant. That is to say, the person should not transfer the property in such a way wherein it is not actually transferred to the transferee or to the grantee, and thereby the grantee is not in a position to make use of that particular property. So here the grantor shall not derogate from his own grant. Second is res isorira sequatur rem principalior, which means if the property to be transferred is, suppose if it is a land, the subject matter of the property is land, or if the subject matter of my property is a machinery, or if the subject matter is a house, then in that case the following would be considered to be a legal incident, because we are considering that whenever a property is transferred from a living person to the another living person, and if that particular property is transferred either wholly or absolutely, suppose if it is transferred wholly, then in that case the transferee would be getting a right to have a control over that particular property. But whenever we say that a particular property is the subject, the particular property which is the subject matter of the transfer is a land, then in that case the following things would be considered to be attached to it, and this would be nothing but called as a legal incident. Now legal incident in relation to the land includes following: firstly, the easement attached to it; second, the rent and the profits occurring after the transfer; and all the things attached to the earth. This is all what the transferee would be getting whenever suppose he purchases a land by way of a sale. So he'll be getting a easement attached to it, he'll be getting a rent and the profit occurring after the transfer, and all the things attached to the earth, maybe in the form of any form if the property is transferred, maybe the sale, maybe the mortgage, maybe the lease, maybe the gift, whatever in form the land is transferred to the transferee, the things attached to these particular land which cannot be removed from the land, because this is all what we considered it to be an immovable property attached to the land itself. Easement is an immovable property attached to the land. The rent and the profit occurring from that particular property would be considered to be a land. You remember we fisherman taking a fish out of the pond or a lake would be considered to be a immovable property, and hence a right to fishing cannot be transferred. So right to obtain a rent profit occurring out of the particular transfer cannot be considered to be a transferable property, and hence would be considered to be attached with the land itself, and therefore it would be considered to be a legal incident and non-transferable under Transfer of Property Act. But whenever a land we are transferring, then in that case, because the rent and the profit occurring out of that particular transfer, the right of easement and all the other things attached to the earth loses its separate identity once it is covered under the head land, then in that case whenever we are transferring a land from one person to the another, then in that case all the things attached to it, the easement attached to it, the rent and the profit occurring after the transfer, and all the things attached to the earth would be considered to be a subject matter which would go as a legal incident along with the land from transferor to the transferee. Next is the machinery. If we take into consideration the subject matter of the transfer is a machinery, then in that case all the movable parts of that particular machinery, all the movable parts of that particular machinery would be considered to be a legal incident, and hence would cover under the head machinery, and accordingly that particular machinery which is permanently with a permanent intention fixed in that particular land, then in that case whatever the movable properties attached to it would also be considered to be a immovable property, and whenever this particular land is transferred, the machinery relating to or machinery attached to that particular land or even a movable parts of that particular machinery would be transferred from transferor to the transferee, because movable parts are nothing but a legal incidents of that particular machinery, and hence it would go along with the machinery from the transferor to the transferee. Next is, suppose if our subject matter of the transfer is a house, then let us see what are the legal incidents which are attached to the house. So firstly, the easement attached to the house, then the rent occurring after the transfer, then the locks, the keys, bars, doors, windows which are of permanent use, then debts, other actionable claims, and those securities which are in relation to these particular debts or the actionable claims would also be moving along with the house and would be considered to be a legal incidents. Not only the students, but the money, their property yielding money, income or interest arising after that particular transfer would also be considered to be a legal incidents which are attached to that particular house, and hence when we are transferring that house, the transferor is transferring that house to the transferee, then in that case all these legal incidents would be covered under the head house and would move from transferor to the transferee. So let us see once more the easement attached to it, the rent occurring after transfer, the locks, keys, bars, doors, windows of permanent use, debts, other actionable claims, those securities, money, their property, yielding money, income or interest arising after transfer would be considered to be a legal incidents and would be moving along with the house, because all these things, easement attached to it, rent occurring after transfer, lock, keys, bars, doors, windows, permanent use, debts, etc. are nothing but would be losing their separate identity when being separated from the house. But because now these are subject matter legal incidents of the house, and therefore they are considered to be lose their identity and become a part and parcel of the house itself, are covered under the head house itself, and therefore whenever a transferor transfers this house to some another person, all these legal incidents attached to the house would be considered to be a transferable one along with the house, and the transferee would be getting a right over these particular properties. Now next is this maxim. Actually this maxim is the basic idea behind this operation of transfer. This maxim, what does this maxim says? This maxim pronunciation is at res magis valet quem paret. This means where the document admits of two construction. Whenever a document relating to any of the particular property gives us two instinct or makes us two construction here means what? Rules of interpretation you have to follow over here. Whenever we have a two documents, the sentence or framed or whatever the things which are written in that particular document, if gives two or if gives two idea about that particular property or a documentation, first idea is gives a sensible effect to the whole, whatever the content of that particular document relating to that particular property, if gives a sensible effect. Second, if makes a portion of it ideal and insensible. That is to say, the documents which part is nothing but a portion of ideal and the another portion is insensible. Then in that case, if it is possible that we to separate the ideal and insensible thing, then in that case we will be deleting or we would be disobeying the insensible thing. But suppose for example if it is not possible, then in that case we would give effect to those interpretation which are sensible to give effect to the whole legal incidents or attached to the particular property which the transferor intend to transfer to the transferee. Now next is this is students very important doctrine, and you may receive a short question over this particular doctrine. Doctrine of lost grant. Doctrine of lost grant means what? Doctrine of lost grant says that once you've been given a permission, okay, to use that particular land, but you've been given a permission, you cannot have a right over the same, and whenever you will be claiming it to be a right, then in that case that is not permissible. This is the simple meaning of this doctrine of lost grant. Now let us see with the help of an example. Supreme Court in AIR 2003 in Tulsi Ram versus Mathura Sagar Pan Tatha Krishi has decided this particular norm by, and this doctrine can be explained by giving following example. Firstly, if a pond artificially made is belonging to a cultivator community of the village were used uninterruptedly for years by fishermen community of the same village. एक पॉन्ड आर्टिफिशियली बनाया गया है कल्टीवेटर कम्युनिटी के द्वारा जो उस पर्टिकुलर गांव की रहने वाली है, और इस पर्टिकुलर पॉन्ड को फिशरमैन कम्युनिटी जो है वो अनइंटरप्टेडली काफी सालों से बेसिकली देखा जाए तो यूज कर रही है. एंड इफ द फिशरमैन राइट कुड नॉट बी ट्रेस्ड ईदर टू अ ग्रांट, custom or a presumption, then in that case cultivator community can restrain the fishing community from using the tank. अगर फिशरमैन का राइट उस पर्टिकुलर प्रॉपर्टी पे हम गए काफी सालों से कोई ग्रांट के रूप में ट्रेस नहीं कर पा रहे हैं, किसी कस्टम के रूप में ट्रेस नहीं कर पा रहे हैं, या फिर प्रजम्पशन के रूप में ट्रेस नहीं कर पा रहे हैं, देन इन दैट केस डेफिनेटली कल्टीवेटर कम्युनिटी जो है वो रोक सकती है फिशरमैन कम्युनिटी को फ्रॉम यूजिंग दैट पर्टिकुलर टैंक और अ पॉन्ड. So this is nothing but a doctrine of lost grant. Student, apart of that, I would say there is there is nothing in the section 8 which talks about the operation of transfer. I hope you have understood.